Hello, everybody. Everybody, get in here. Hit the like button. Let everybody know that we're in here. Hit the like button. Comment. Let me know where you're from. I see a few people trickling in. It's kind of a spontaneous live. I just kind of figured you gotta just go live when there's news, right? See what's going on. It's almost the last night of the year. What's everybody doing for New Year's Eve? What's everybody doing for New Year's Eve? I'm going to the Rose Bowl on the 1st. It's going to be exciting, but we've got some another filing on the Jay-Z front. Some news in the lawsuit that Tony Buzbee filed against him. So I wanted to get into it with you all. Give me a comment. Let me know who's all in here. I'm building up the channel, trying to get some more members. I've got some memberships going. So I usually have some members, but like I said, I just planned this like half an hour ago, and it's family time for a lot of people in the United States. I see watching from Norway. Thank you. Thank you for saying hi. Thank you for saying hi from Norway. We've got an interesting filing in the Jay-Z lawsuit that basically previews a dismissal motion that he's going to file. Hi, Trakisha from Maryland. Hello, hello, hello. Thank you for saying hi. Everybody trickle in here, hit the like button. Let us know where you're from. From Chicago. Must be a little cold there. Thank you, T. Morton, for saying hi. Cherry from St. Louis. Hey, hey, hey. We've got Missouri represented. We've got Oakland represented. Hello from Oakland. Key LX. All right, we've got a few here. Oh, our best friends in Oslo. That's great. Is it Per Peterson, the author from Norway? I read a lot of his books. He's the best. Hello from New Jersey. And Detroit, the Bailey Barrack Show. Thanks for saying hi from Detroit. Atlanta, Georgia. Wilmington, North Carolina. Do I have that right? WNC. Atlanta, Georgia. Charles Roundtree. Thanks for saying hi. Hey, hey, hey. N8 Squeeze, Virginia. Great. Well, hey, everybody. Thank you once again for coming in. It's the second last night of the year, kind of the time when a lot of people are hibernating. A Western NC. Western NC, I have that. Okay, I got that wrong. Yeah. Upstate New York. There we go. Upstate New York. But it's that time of the year where a lot of people are hibernating and not paying attention to the news. But so thanks to everybody for taking a few minutes to come on in. We've got Key Largo, just like the Carl Hiaasen books. New York City. Thanks for saying hi, Jamel. What books are on my list from this year to read? I did not do as much reading this year as I should have, but anything by Per Peterson, and I did so much work with the Young Thug trial and everything. I kind of neglected my fiction reading, but I'm going to get back into that. And the news is, I think everybody who is here probably saw the story from last week about the judge finally weighing in on the Jay-Z case and all these filings from Alex Spiro. But let me put the article up on the screen this is my website, legalaffairsandtrials.com. You guys go check it out. It's what I have my Substack hosted under. So I've got a lot of good stuff on there. But if you sign up, you get my articles in your email inbox. I'm going to be doing a top 10 list tomorrow, my 10 stories of 2024, top 10 cases. But this is the news from just the other day. Judge Annalisa Torres won't strike the rape claim against Jay-Z, says plaintiff can proceed anonymously. So the request that she addressed here was not really not a dismissal motion, but Alex Spiro had requested that she strike the amended complaint, not even allow that amended complaint to go forward on the docket, which would have put the case back at just the first complaint that was filed against just Diddy. and she rejected that, said that his reasons for it were like the outlandish actions by Tony Buzbee, but she rejected that here in the order. But today he filed a letter that previews an actual dismissal motion that he's going to file, because there's a difference between a motion to strike and a motion to dismiss. So today, one things he won on in the judge's order, Alex Spiro, Judge Annalisa Torres set a briefing schedule on his motion to preserve evidence, because he had filed a motion to preserve evidence asking the judge to order Tony Buzbee to preserve any evidence related to this case, saying that Tony Buzbee's ethics or his ethical problems mean that he could destroy evidence showing that this case was fabricated, or showing his untoward actions in it. And she hadn't rejected it. She had set a briefing schedule, and Tony Buzbee had until January 10th to respond. But today, Alex Spiro said, this is actually another one, but he's withdrawing the motion because he's saying that he served Buzbee with a notice to preserve evidence. So the order is technically already in effect. And I know some people are wondering, well, how can he trust that Buzbee would actually do it? But it's kind of the same thing if there was a judge's order. I mean, it's kind of just Scout's honor that you would actually do this. But I don't think we're going to be like hearing about this much more. I mean, this would come later on after the case is dismissed, if they're really pursuing that defamation claim that they filed in LA Superior Court. We might hear more about, what would come from a motion to preserve evidence, or what kind of evidence would be preserved, and how would they go through the discovery process on this. Here comes Drama. Thank you for saying hi. One of my members, one of my loyal members. I appreciate it so much. Thank you for reminding everyone to like and share. And Tavon, tapping in from Cleveland, Ohio. What's up? Case not dismissed, but Spiro did file a letter. Really, I was, I'm kind of hibernating. A lot of people are kind of hibernating right now, so we're not like totally in work mode, but I was on a train somewhere when I saw this get filed. So this is the first filing that I saw, was him withdrawing the motion. But really, probably the more significant one that I should have put up top if I saw it first. That's just the one that I saw first, so I posted it. But this is the one where he previews his upcoming dismissal motion. It's not the actual dismissal motion, but he's following the court procedure for writing a letter asking permission to something. I don't know, the court, especially federal court, it just gets a little but let me see if I can pull this up so we can actually read it. I know it's a little small on the screen here. But of course, and this is actually what we see in a lot of dismissal motions. I saw some people online kind of taking issue with the arguments he was making in it, because of course he's overall saying that this isn't true at all, that this lawsuit is just completely fabricated. But the letter here in kind of previews a dismissal motion that would focus on statute of limitations, jurisdiction, because he's arguing that this white mansion or something that's she talks about in the complaint about where she went after the awards party. He's saying that can't possibly be in NYC. It must be in New Jersey, which shows that the law that she's filed a claim under is NYC specific. So he's going to argue for dismissal on that, but he previews his other reasons. Somebody asked if it's a victory for Buzbee. I don't think so. I mean, it's kind of neutral. Like the last one, the ruling from the judge was definitely like favorable to Buzbee, because she smacked down Spiro and said that he was behaving inappropriately, and she didn't strike the complaint and everything. But this is Spiro just going through the process, like saying that he's going to file this dismissal motion. And the fact that he withdrew the motion that motion to preserve evidence was always like, it was really kind of performative, the fact that he filed it. Like when you read it's very a chance for him to air out all of Tony Buzbee's laundry in a court motion that like the press will pick up, but there must be some kind of process where he has to serve him first, or he should serve him first, but he just realized that there really is no conflict or pushback from Buzbee on accepting a motion to preserve evidence, or an order to preserve evidence, request to preserve evidence. So they're just going about it that way. So I think it's kind of just, it's kind of just neutral. But let me see if because I did play, I'm gonna cite the post the video again too on here. I've got the video. YouTube finally approved it, but here, I played this in my last live, but this is the video that Spiro made previewing or explaining why the woman's story doesn't add up. And I kind of agree with Cher when she says too much theatrics from these lawyers. And obviously this video was made for the press. This was handed out to the press. It's a summary of what he presented to the press in New York City, which obviously I didn't go to because I live on the West Coast. But the thing is, when you read his actual dismissal motion, it's not like he's arguing factual issues, because that's something that the jury would actually decide. This stuff about the statute of limitations and whether the NYC law that she filed a claim under can actually apply, those are the kind of legal issues that you would expect to see in a dismissal motion. So while this video that I'm going to play is compelling and that it highlights all these problems in her narrative, it's just kind of premature for him to bring this out, because it's frankly kind of giving a roadmap to potential witnesses that he might have to do depositions for. Because when you look at all this stuff, they're very prepared to go forward, but it's like, are they kind of tipping their hand a little bit? Because just this video is not going to give the judge a reason to dismiss this lawsuit. And I'm going to have to dig into some of the dismissal motions. There's only been a couple, I think. But one in particular, there was a dismissal motion brought by Diddy's lawyers in this lawsuit that's with Jessica Clark. And she ruled on that already and actually dismissed his companies, but did not dismiss him. So that's moving forward. So I want to go back and look at that motion to see what arguments they made. But if there are any legal arguments to actually lead to dismissal, that's what would do it, not these kind of factual things, because the judge would see this and be like, well, these are more issues for the jury. But so I'm kind of wondering if it's a little premature for him to, he's trying to sway public opinion, but it's like, is Alex Spiro actually kind of tipping his hand for potential depositions by putting this all out here? But here, I'll play the video again for people who haven't seen it. I'll queue up some more documents while I do.
As we look and review these alleged accusations against Mr. Carter, the timeline and details that Jane Doe has provided in her formal complaint do not create a scenario in which any of the accusations are plausible or possible. Time doesn't lie. These accusations bring to question all details of the complaint, the reasonable timing of each moment, and how this all could have happened, which is irrefutably not possible. In her complaint, Jane Doe states that these points: she snuck out of her window and had a friend drive her to the VMA location, Radio City Music Hall. To get to the after party, the drive from the VMAs to the residence was 20 minutes, that the driver had to drive Diddy to the after party first from the VMAs, then come back to get her to bring her to the after party, that Diddy and Mr. Carter were at the residence by the time she arrived, that after the alleged sexual assault, she navigated through the party to the exit and ran to the nearest gas station to call her father to pick her up, and that her father picked her up before dawn. To establish all of these alleged timings and make sense of a plausible timeline, we've started with the facts to understand the start and end to the alleged incident, which did not happen. Jane Doe, on the day and year, lived in Rochester, New York, over a 5-hour drive without traffic to Radio City Music Hall. The VMA's broadcast and show started at 8 p.m., which Jane Doe claims she watched outside on a Jumbotron. She would have had to leave her home at 2 p.m. to get to Radio City Music Hall on time to watch celebrities arrive, she claims, and be there for the start of the show. Jane Doe claims that her father picked her up before dawn on September 8th. Dawn on that day was at 6:29 a.m. For her father to drive from Rochester to pick her up, the latest the phone call from the gas station would have had to have been at 1:30 a.m. That establishes the start and end to our alleged timeline. Now let's work through the facts. The VMAs in 2000 ended at 11:11 p.m. Jane Doe said that the driver had to drive Diddy to the after party, come back to get her, then drive her to the party. She also stated that the drive was 20 minutes. That in total would have been 20 minutes times 3, which is 1 hour total of drive time. The earliest the driver could have picked her up is at 11:51 p.m., making the earliest the driver could have dropped her off at the alleged residence is 12:11 a.m. Irrespective of the details of the residence, this now establishes that the earliest she could have been at the residence is 12:11 a.m. Now, for her to call her father from a gas station at 1:30 a.m., we have to establish how close is the gas station from the residence. Out of the possible locations for the white residence, the nearest gas station is 42-minute walking distance. That means that the latest that Jane Doe could have left the residence after the alleged incident is 12:48 a.m. That creates 37 minutes for this 13-year-old girl to be at the party, talk to celebrities, have a portion of a drink, and for the alleged sexual assault to happen. For her to run out of the house, be in an area she knows nothing about, knows no direction as to how to get anywhere in the middle of the night, and find her way to the nearest gas station 42 minutes away to call her father to pick her up. This is all assuming that everyone left exactly on time at 11:11 p.m. once the VMAs ended, that there was no traffic after the VMAs in the 3 drives the driver made to transport Diddy and Jane Doe to the party. This is also assuming that Diddy and Miss Lopez did not attend any other after parties in the 1-hour period before Jane Doe arrived to the party, and separately, Mr. Carter either, and that without any directions in the middle of the night in an area she is unaware of, Jane Doe made it on foot to a gas station in 42 minutes. This is all not possible and irrefutably false. This alleged incident and timeline are not plausible, and this did not happen. This timeline is absolutely not plausible, as both Diddy and Miss Lopez are photographed at other VMA after-parties at commercial establishments at the time in question, and separately Mr. Carter as well, none of which are the described white residents in Jane Doe's complaint. In these pictures, you can see Diddy and Miss Lopez changed clothes from the VMAs, went to multiple commercial nightclubs, including Lotus and Twirl, and none were the White House described in Jane Doe's complaint. This incident did not happen. Now, to speak on the white residence that is described in Jane Doe's complaint, she describes it as a large white residence with a gated U-shaped driveway, and she says it was 20 minutes from Radio City. There are no houses matching Jane Doe's allegations within the 20-minute drive from Radio City Music Hall. To dive deeper into the details, there are 2 possible residences in Diddy's life during that period of time, but none match Jane Doe's description. There's a Manhattan townhouse that does not match the description. There's a Hamptons home over 2 hours drive away. There are 2 residences in New Jersey. One was sold in 1998, years before the alleged incident. One was purchased in 2004, after the alleged incident. In fact, there is no home in Manhattan gated with a U-shaped driveway. All in all, time doesn't lie. The location of Jane Doe's alleged incident does not exist. The alleged timeline of the incident is not possible. Diddy and Miss Lopez were at other after-parties at commercial establishments during the time in question. And separately, Mr. Carter was also at other after-parties at commercial establishments at the time in question. Jane Doe's father even confirmed that he does not remember driving 5 hours both ways to pick up his 13-year-old daughter on the night in question. In addition, Jane Doe claims that she spoke to Benji Madden about his tattoo at the party at the white residence, but Benji Madden confirmed that he wasn't in attendance as he was on tour in a different state at the time. This event is provably false and did not happen.
So yes, that was the video. But the dismissal motion that he's previewing today, Alex Spiro filed a letter previewing his dismissal motion, is focused on other things. So we'll bring that up here. But D-Doc, thank you so much for the super chat. Appreciate it. Got to keep it going in here. But as everybody is kind of hearing, I'm building up the channel, trying to get more members and everything. So check it out and show the love. Hit a like if hit the like button if you can. But the letter that Spiro filed today, here, let's get it up on the screen here, is not the dismissal motion. Now, this is not Alex Spiro's dismissal motion, but it's his letter previewing his dismissal motion. So he says, "We write on behalf of defendant Sean Carter, pursuant to the judge's individual practices in civil cases, to inform the court that Mr. Carter seeks to file a motion pursuant to federal rules of civil procedure. So that's new to me. The judges that I cover in Los Angeles and Orange County, the federal judges, don't have a rule, at least I don't think all of them do, where you have to like ask permission to file a motion in a civil case. But apparently Judge Torres does. So this is him writing to ask permission basically to file the dismissal motion. And it says on December 19th, Mr. Carter sent a letter to plaintiff setting forth the basis for this motion and advising that Mr. Carter would file this pre-motion letter if plaintiff chose to stand on her first amended complaint. Plaintiff was required, but failed to respond to Mr. Carter's letter within 5 business days by December 27th. Mr. Carter interprets plaintiff's silence as confirmation that she will stand on the first amended complaint as pled. Accordingly, Mr. Carter submits this pre-motion letter concerning the anticipated motion to dismiss, which will raise the following arguments. First, plaintiff cannot recover for her sole claim under the Victims of Gender-Motivated Violence Protection Act as a matter of law because the statute does not have retroactive effect. Plaintiff asserts a violation of the GMV law for conduct that purportedly occurred in September 2000. But the GMV law was not activated until December 19, 2000, 3 months after the first amended complaint claims the conduct occurred, and cannot apply retroactively to create a cause of action unavailable to plaintiff at the time in question. And he has a case just from 2023. Recently, like a year ago, another judge looks like dismissed a case brought under that for that reason. Says a contrary conclusion would violate both state and federal due process protections. Second, even if the GMV law had retroactive effect, it does not. To prevail, plaintiff must show that the violative conduct was committed within New York City. The first amended complaint alleges that the violative conduct is forced sexual conduct, but does not assert that this conduct occurred in New York City. Could it? According to the first amended complaint, plaintiff was driven from Radio City Music Hall to, quote, a large white residence with a gated U-shaped driveway, a drive that took 20 minutes. This is where the alleged assault took place. The first amended complaint's description of the residence in question, however, combined with public records, confirms that any such residence, to the extent it existed at the time, would have been located outside the territorial boundaries of New York City. As such, assuming the well-pled factual allegations are true, they are not, they cannot plausibly state a claim for relief. So it's kind of a backup to his first argument there. Third, any viable GMV law claim is time barred under New York City's Child Victims Act, which preempts plaintiff's GMV law claim. The first amended complaint alleges the conduct occurred 20 plus years ago, well outside the CVA's statute of limitations. Though the CVA was amended in 2019 to create a 2-year and 6-month revival period, that period expired in August 2021. Plaintiff seeks to plead around the statute of limitations issue by asserting a claim under the GMV law, which contains a longer revival period. Courts in this district, however, have recognized that the CVA's revival period preempts the GMV's law overlapping an extended one. As such, plaintiff's claim expired no later than August 2021. So basically that's because she was a child, because she was 13. They're saying that this other law should apply and it would be expired. And I know, like I said earlier, I know a lot of people are saying, well, some people I've seen online say, you know, oh, well, they're saying this didn't happen. And now they're saying that, oh, it's because of the statute of limitations. But legally, this is just what they have to do. I mean, dismissal motions typically deal with this kind of stuff, not, you know, here's why the factual allegations are bullshit, but it's like, here's why legally this isn't pled correctly, or it just can't go to a jury. Like the factual disputes should never, you know, go before a jury because of these problems legally with the pleadings. So that's what they're doing here. And like I said, this is not the actual dismissal motion. This is just his letter requesting permission from the judge to file a dismissal motion in accordance with her rules. So I'm a little unclear if he actually files a dismissal motion. Of course, we're going to see an opposition filed from Tony Buzbee responding to all this stuff. I'm not sure if the process will, if we're going to see a response from Tony Buzbee to just this letter, but we'll see. It seems likely that the judge is going to allow him to file a dismissal motion. I mean, I don't see why she wouldn't. Dismissal motions are completely common. I mean, that's kind of exactly what you would expect to see in a case like this. But like I said, most of the judges I cover, the federal judges in LA and OC, don't ask people to ask permission to file motions. So I'm wondering if it's just kind of procedure for her. But so that's the big thing. I don't know how soon it could be filed, when she's going to address this letter, or if we'll hear from Tony Buzbee on it. But I would expect sometime in January, maybe late January, we'll see the actual dismissal motion. And it's going to be a heck of a lot longer than 2 pages. Like the way he just went through these issues and kind of listed out, it's like a paragraph about each. It's going to be, it could be 30 plus pages. She might have actual length limits, so they can't just go crazy in their filings, but I'm sure it'll be longer than 2 pages. So, so somebody says, why would a judge make a ruling for a dismissal motion? And the first one I see as having the most, the best argument. When there's issues like the statute of limitations or failure to state a claim, like they're arguing something that just doesn't apply, things like that. Let me see if I can bring up the dismissal motion that Diddy filed in the Jessica Clark, the case that's with Judge Clark. There's so many Doe versus Combs lawsuits now because most of them are all filed under Doe versus Combs. But the dismissal motion that Diddy filed in this one lawsuit that's been ruled on was about that same gender motivated act. I can't remember quite what his argument was, but it was about, she didn't buy it. Like, she rejected dismissal, but she did rule that the companies wouldn't proceed under it. So he could get that same thing here. But it sounds like a few other judges have been dealing with this gender motivated violation of the New York City gender motivated act, and which is the claim that Buzbee is bringing in quite a bit of this stuff. So this is actually the case file right here for the Diddy Doe versus Combs, the Clark case, which I'm kind of waiting for him to file a stay on that because they were going through the dismissal motions. She's identified herself, but like I said, with him having a criminal case pending, he's definitely not ever going to go sit for a deposition as long as his criminal case is pending. So I'm kind of just assuming this is all going to be stayed soon. But there's an amended complaint. Harvey Pierre of the third assailant. Interesting. Remember this Harvey Pierre, and yeah, this was against Harvey Pierre, and it says there's a third assailant. This isn't a Tony Buzbee lawsuit, though. And these are the same lawyers, the plaintiff lawyers. I mean, they're much better than Tony Buzbee's firm, much more respectable. But it's Wigder Law LLP, which is the attorneys who represent Cassie. So this is the company's Bad Boy Entertainment. Did he file one? This is kind of just what you got to do when you're reporting on stuff. There's so much to look at. Okay, yeah, this is Jonathan Davis. This is the dismissal motion from Diddy's lawyers. This is, well, I hate that. You see the motion. You got to remember not to go to the motion. It's the memorandum. Yeah. Memorandum of law and support. Yeah, see, the arguments that Diddy's lawyers raised in their dismissal motions, other lawsuit, are similar in that they're not just like, although they do say that it didn't happen and it's not true and these are fabricated claims, their dismissal motion is about like other like legal issues related to the actual pleading here. Plaintiff's claim is time barred because the VGM's claim revival provision is preempted by the ASA and CVA. Okay, that's the same argument that Spiro is going to make in his dismissal motion, that the CVA, which is that Child Victims Act, applies, and because of that, her claims are time barred. So the Judge Clark already rejected that argument in this dismissal motion. So that kind of leans toward, I mean, that's not that does not bode well for Judge Torres finding the other way. But you know, all cases are different. There's like fact specific cases that they need to look at, and it might be a little different here. But I mean, the other point they made was this is against the corporate defendants. In this case, Judge Clark ruled that, yeah, the corporate defendants aren't going to proceed as defendants. So that was obviously somewhat of a win, but I mean, kind of not really, because Diddy is still proceeding. And that's not really an argument that Jay-Z is going to make, because he doesn't have corporate defendants to worry about. It's just him right now. So, and that was the alleged misconduct of the individual defendants cannot be imputed to the corporate defendants. And these are the arguments I think the judge went for. I'd have to read her actual dismissal motion to see what she said. But like I said, she ruled that the corporate defendants weren't going to go forward, but that the individuals would, meaning Diddy. So that's basically what we're going to be seeing in the Jay-Z lawsuit with when Spiro files his letter, or once he files his actual motion. Like I said, this is just a requesting permission to file it. I wonder how long the judge has had that rule that they need to ask permission in civil cases to file motions, because I know, just as somebody who's spent a lot of time with federal judges and around federal judges and just all the different cases that they have, civil attorneys are out of control, and a lot of it the judges just get so sick of them, because most of these cases should be in private mediation. And when I was talking to a clerk about a civil case once where there was just like all these filings left and right, and I was like, oh wow, there's another filing, and she's like, yeah, they never stop. Exactly. Like, so I wonder how long she's had that. You got to ask permission before you file something. I'm not sure I'd say the judge is taking this personal. Because, I mean, Spiro's filings is like, I cover a lot of federal court stuff, and his filings were just like, no judge on the planet would like go for what he was asking for. And she's been on the bench for like 11 years, you know. I mean, the way they were just demanding hearings at like filing something at like Wednesday afternoon and asking for a hearing at like Thursday at 9 a.m. It was like, kind of expected her to do that, you know. Going forward, I don't think it's really going to like, it's not like she's going to like hold a grudge against him going forward and stuff. I mean, I wouldn't think so. But because if he has actual valid issues in this dismissal motion, she's definitely gonna look at him. But like I said, it's very focused on legal arguments, and a lot of these civil claims have moved forward. Like I said, Judge Clark rejected the corporate defendants in some of it, but in the Diddy lawsuit, but is allowing Diddy to move forward as a defendant. So, oh hey, figure out how to get the document here. There you go. There you go. So again, you pull up the tweet here. I don't know how everybody found the live, but oh, look at that. The Rose Bowl. Doesn't that look cool? Oh yeah, and I thought this was interesting. So there's at least two of the sexual assault lawsuits that Buzbee has filed against just Diddy. The Jane Doe versus Combs lawsuits were scheduled for status conferences on January 10th, and he's written pretty much the same letter. It's his co-counsel in New York City has written asking to adjourn them because, one, they say they want Buzbee to present, and he's not available on that date. But then they also say they're having delays with actually serving Combs with the lawsuit, Diddy with the lawsuit. And they said face delays caused by defendant Combs refusing to leave his cell to accept service. But they think they're working it out now, and et cetera, et cetera. But I thought that was kind of interesting. That's not the Jay-Z lawsuit though. But yeah, again, kind of the big news is today, the big news would be Jay-Z's lawyer, Alex Spiro, filed a letter indicating he's going to be filing a motion to dismiss. Again, got the letter here. Let's see if I'll pull it up here. Yeah, again, the news is Jay-Z's lawyer, Alex Spiro, is asking permission to file a dismissal motion against the rape lawsuit that was brought by Tony Buzbee against Jay-Z that alleges he and Diddy attacked a 13-year-old girl after the Video Music Awards in 2000. And of course, he vehemently denies all the allegations and says that the story is completely false. His dismissal motion is focusing on various legal issues with the pleadings, such as whether the city law regarding gender motivated violence actually applies, and whether there's like a statute of limitations issue with the incident being so old. And then also the same argument that Diddy made in his lawsuit against in his dismissal motion about, because of the alleged victim's age, means that instead of the gender motivated act applying, a different law should apply regarding child victims. And if that's the case, the statute of limitations on that has already expired. So it definitely stays away from factual arguments about the other stuff we've seen, because she denied that the judge denied the motion to strike the complaint that was really brought based on a lot of Tony Buzbee's tactics and some problems with the complaint. But this is now, dismissal motion is now focused on different legal issues. But I think we can still expect all those other arguments to be made. So yeah. I think that's about it. Not sure. Is there special rules for child victims with disabilities? I'm not sure. They haven't specified that this Child Victims Act that they're citing has any kind of special mention of children with disabilities or anything like that. So we have not seen that yet, but we'll see. But also another thing that happened today was Spiro is withdrawing his motion about Tony Buzbee preserving evidence in the rape lawsuit. It was a motion seeking an order to show cause against Buzbee, which is kind of just a complicated, long process thing. But he ended up, Spiro's firm served Buzbee with a notice to do just that, or Buzbee's co-counsel, because it was said that he could accept service through them. So that's that. So again, the probably bigger news is Jay-Z's lawyer, Alex Spiro, asking permission to file his dismissal motion, and then really previewing the dismissal motion in his filing, focusing on the fact, probably the most interesting argument is the argument that this couldn't have happened in New York City just based on the description of the house. He says, according to the first amended complaint, plaintiff was driven from Radio City Music Hall to a large white residence with a gated U-shaped driveway, a drive that took 20 minutes. This is where the alleged assault took place. The First Amendment complaint's description of the residence in question, however, combined with public records, confirms that any such residence, to the extent it existed at the time, would have been located outside the territorial boundaries of New York City. So it'll be interesting to see what the response is for that and how they expand on that more when they actually file their dismissal motion. Because like I said, I would expect the actual dismissal motion when they file it to be much, much longer. And we're going to have to hear from the judge on this, but I think it's kind of weird that she's would make them ask for permission to file a dismissal motion. I mean, that's kind of a basic thing that you would see in this case, in a case like this. But so it seems kind of given that she's going to approve it and let him file it. But I don't know. I've been wrong before, so we'll see. But that seems like a pretty basic one. But yeah, so that was pretty much it. I just wanted to go on and break it down for you guys a little bit. I need to be a little more proactive about going live, even if it's like December 30th and not much of a notice. But I got to do what I can to stay in the algorithm and build up the channel, right? But if you guys want to hit the like button, show me some love. Yeah, thank you, Takesha, for tuning in. I hopefully will be going live again next week with some more news. I guess it's this week. It's just such a weird period now where nobody even really knows what day it is. But I will definitely be keeping you guys updated on the filings. And if you get a chance, go to my website, legalaffairsandtrials.com. I'm going to be sending out my top 10 stories tomorrow. Should be a good one. And yeah, thank you all so much. I'll see you guys later.